with Epicentre. No ambiguity, no noise. Let's come straight to the point. Amongst the post-colonial societies, India stands tall as a shining beacon of democracy. Other than very few aberrations, India has been able to maintain her democratic character and shine on as world's largest democracy. Upon India's independence, India's big moment was to give herself a truly liberal and progressive constitution. Since then, the constitution has been identified as the foundation of the republic and democracy, and Supreme Court is the guardian of this constitution. However, there are two schools of thought in the country today. One that feels that India's success as a democracy is only because of her constitution and limitations it puts on the executive and legislature. This group feels that the constitution is paramount and supersedes will of the people. They feel the source of goodness in India flows from the imposition of constitution in letter and in spirit. There's another school of thought and which believes that India's constitution is a colonial legacy. It does not take into account civilizational past of India. It gives no credence to India's rich heritage. India as a nation predates the framing of its constitution. India as a nation predates the freedom struggle. And India as a nation predates the arrival of all those who eventually made India their homeland. If India stands tall as a pluralistic democracy, it is because of its people who are inherently democratic and tolerant. No law on this planet can make people tolerant and democratic if the society does not place value on these ideas. This group feels the judiciary's job should be strictly interpreting constitution and ensuring checks and balances. The guardian of the constitution should not become the moral guardian of the society. While these two sides of the debate are raging, India, with its codified constitution, is a constitutional democracy. But what is a constitutional democracy in the Indian context? And what is the role of judiciary in it? We see judiciary and executive often batting it out in the headlines of newspapers. Is that a good thing? Is that good for the health of our democracy? To me, yes. Judiciary and democracy and judiciary and executive have always been at loggerheads. This is nothing new. And it is good when they are debating and talking about things in public, when it is transparent. When is it a problem? It is a problem when there is a collusion. We hope there is never a collusion between the two. To talk about all this, I couldn't have asked for a better guest. My guest on Epicentre today is Mr. Sakal Bhushan, a frequent commentator on issues related to constitution, law, and the political and social affairs. Mr. Bhushan is a practicing lawyer at the Supreme Court of India and Delhi High Court. I have often read his columns, I have read his interventions in the courts, and I am pretty amazed at his clarity about constitution and about our constitutional democracy. I am so glad that Mr. Bhushan has accepted my invitation to be here. Welcome to the show, Mr. Bhushan.
Thanks, Sunanda, for inviting me to the show.
Welcome. I want to start with a very basic concept. What happens is a lot of times we get confused between even the basic things like difference between constitutional democracy and the parliamentary democracy. We know that India is a parliamentary democracy because parliament, we elect a parliament, ruling party then elects its leader, who then becomes the prime minister. So we know that we're not a presidential form of government. But then this is different from what we mean by constitutional democracy. So I think that's a good place to start. Why don't you tell us, what is a constitutional democracy? And was India always a constitutional democracy, or is this something that came later?
Very pertinent question to start with, because the topic of today is the role of judiciary in constitutional democracy. So first of all, we must be very clear about what is constitutional democracy at all. You talked about parliamentary democracy. I beg to differ. Parliamentary democracy is only a form of government.
Right.
That where there is a parliament and parliament makes the law. But ultimately, India has adopted the constitutional democracy. Democracy, everybody knows. Constitutional democracy is that democracy which is governed by a written constitution. There is a written constitution. All authorities are created under the constitution. All authorities are given powers under the constitution. All authorities take their oath of allegiance to the constitution. I will read some of the oaths prescribed under the Indian constitution, which would prove the point that all the authorities, be it a judge of the High Court or the Supreme Court or member of parliament or the union minister or minister of state, in every oath you will find the expression, I do hereby declare my allegiance to the Constitution of India as by law established. So, the constitutional democracy is a democracy which is governed by a written constitution, which is based upon the principle of separation of powers. There is clear cut separation of powers. Executive is given its own role, legislature is given its own role, and judiciary is given its own role. Problem only arises when one authority transgresses into the field which other authority thinks is their own domain. And sometimes there is misunderstanding because there are interdisciplinary approaches, and sometimes a lot of misunderstanding is created, and it is because of that lot of problems arise. So, in this show, as the show proceeds, you will ask me further questions. I will delve deep into this. But if you permit me, right now, in order to prove my point, I will only tell one thing, that there is Schedule 3 in the Constitution of India,
Correct.
in which different oaths are prescribed, which have to be taken by the minister, which have to be subscribed to by the judge of the Supreme Court, which have to be subscribed to the member of parliament. And I read one oath, and that will clarify the matter.
Go ahead.
The oath which the union minister takes is that I do swear in the name of God that I will bear true faith and allegiance to the Constitution of India as by law established, that I will uphold the sovereignty and integrity of India, that I will faithfully and conscientiously discharge my duties as a minister for the Union, and that I will do right to all manner of people in accordance with the Constitution and the law, without fear or favor, affection or ill will.
Yeah.
Exactly the same oath, roundabout, is taken by the member of parliament, who also says, I will bear true faith and allegiance to the Constitution of India as by law established.
Yeah.
And the same oath is taken by the judge of the Supreme Court, that I will bear true faith and allegiance to the Constitution of India as by law established.
Fair
Nobody
enough.
takes the oath
Yeah.
that I will bear true faith and allegiance to the parliament, or
Yeah.
no parliamentarian takes the oath that I will bear faith and allegiance in the judiciary. So
Yeah.
all people take oath in the name of the Constitution. That
Fair
is
enough. Fair enough. But question here is about the supremacy now. Who has the supremacy? So we agree that we take faith, the oath is on the constitution and all that. We agree that India has a written constitution, therefore it's a constitutional democracy. The question is, what takes what supersedes? So the point is, how do we interpret the constitution? That is more important. And the point is, who gave the constitution? Who gave Supreme Court the authority to be the guardians of the constitution? People themselves, right? The constitution says we the people. So people gave the authority to the constitution. People gave the authority to the Supreme Court. So once you say that we are, the allegiance to the constitution, doesn't it mean it is the allegiance to the will of the people? Because ultimately constitution is the will of the people. And will of the people is presented by the parliament and not by a judiciary, because parliament obviously is legislature and executive. They are elected by people.
So the answer to this question is to be found in the history of the Constitution. The Constitution has been framed by the Constituent Assembly, which stands dissolved, right, long ago. And now, after that, there is a parliament which is created under the Constitution. Parliament is not the father of the constitution. Parliament is the creation of the constitution. So that we will answer this question when we will talk about the basic rights theory. We will talk about the basic structure theory in the later part of the program. But right now, my answer is that none is supreme and everybody is supreme. My answer is paradoxical. Everybody is supreme in their own defined sphere, and nobody has supremacy over the other. That's the crux of the answer. So there is a clear-cut, defined division between the roles which the various authorities have to prescribe, perform.
Fair enough. Fair enough. How do you think the judges should interpret constitution? Should it be according to the letter and spirit of the constitution, or is constitution to be thought of as a living document? Because ultimately constitution is also a document. It is a product of its time. It will be a product of its time. It will become obsolete. It will become old. It will become not contemporary if it is not if we are not sort of following the intent of the constitution, or if we are not interpreting it rightly. So what do you think is the right way of interpreting the constitution?
The answer to this question lies in that everything has to be flexible in order to survive.
Right.
And constitution is not an exception to that. We have to only adhere to the basic values. Otherwise, with the experience during the operation of the democracy, there are certain issues which need to be redressed and amendments are required. The answer to the question has been given by the Supreme Court itself in a judgment. With your permission, may I read a paragraph out of that?
Please go ahead.
Please.
Go ahead, please.
There is a very important judgment of the Honorable Supreme Court, which is called Second Judge's Case, which was decided in the year 1993, where the question arose because earlier judgment of the Supreme Court on the same point was in the year 1981, SP Gupta case.
Right.
So that judgment was overruled in 1993 by the Supreme Court, and this question fell for consideration, that what should be the way to interpret the Constitution, because certain dictionary meaning were assigned to certain words in the Constitution in the earlier judgment. The question arose that whether the words are static or they have to be given a lively meaning according to the experiences. So the answer is, it is not, I quote unquote, it is paragraph 420 from that judgment of 1993. It was rendered by 9 judges of the Honorable Supreme Court of that time. It is no doubt correct that the rule of stare decisis brings about consistency and uniformity, but at the same time, it is not inflexible. Whether it is to be followed in a given case or not is a question entirely within the discretion of this court. On a number of occasions, this court has been called upon to reconsider a question already decided. The court, in appropriate cases, overruled its earlier decisions. The process of trial and error, lessons of experience, and force of better reasoning make this court wiser in its judicial functioning. In cases involving vital constitutional issues, this court must feel to bring its opinions into agreement with experience and with the facts newly ascertained. Stare decisis has less relevance in constitutional cases where, save for constitutional amendments, this court is only body able to make needed changes. Re-examination and reconsideration are among the normal processes of intelligent living. We have not refrained from reconsideration of a prior construction of the Constitution that has proved, quote unquote, unsound in principle and unworkable in practice.
Right.
So the Honorable Supreme Court itself answered that with the change of experience, we have to give a different meaning to the static words.
Fair
And
enough.
what was the controversy involved in this case? That we will directly answer when you ask me more questions about the independence of judiciary. But shortly, the expression used in Article 124 of the Indian Constitution, which deals with the appointment of the Supreme Court judges, and 217, Article 217 of the Indian Constitution, which deals with the appointment of the High Court judges. The expression used was that the President shall appoint in consultation with the Chief Justice of India. So the question arose, what do you mean by consultation? Whether consultation is simple consultation or is it concurrence? Considering the principle of separation of power and considering the importance of the independence of judiciary, a meaning has to be assigned to the word consultation, which is not according to the dictionary meaning. So therefore, the question arose whether the words have to be interpreted according to dictionary or according to experiences and the spirit of the Constitution.
Right.
And consultation was interpreted as concurrence. And that is the bone of contention right now, even up to this time.
Yeah. And what is this concurrence? What does the concurrence mean?
The Honorable Supreme Court was very pragmatic when it returned the finding that the consultation means concurrence. After having said so, that consultation means concurrence, they never wanted to vest this power in one single individual, that is Chief Justice of India.
Yeah.
So they created a collegium system. In the year 1993, it was decided that Chief Justice does not mean only Chief Justice. It means Chief Justice and the two senior most judges of the Honorable Supreme Court. They will confer in between themselves and formulate an opinion, and that opinion will be the opinion of the Chief Justice. And that opinion has to be forwarded to the government in the matters of appointment.
Yeah. So, fair point. I have a question here. We are going to go to you talked about the collegium. We are going to talk about the collegium system in a little bit. I want to talk about the major issue, flashpoint right now, which is the Keshwananda Bharati judgment. This is the major flashpoint because here, this is the first time now the Supreme Court tells us that there is a basic structure of the Constitution, and the Parliament and the executive cannot violate that basic structure of the Constitution. Amendments can come and go, but the basic structure of the Constitution cannot be violated. This is the crux of the judgment. Now, who defines the basic? They have not defined the basic character of the Constitution. My question is, why who defines the basic character of the Constitution? And you will tell me, well, the judiciary, because they are the guardians of the Constitution, so they should decide the basic character of the Constitution. So my counterpoint to that is, why haven't they done it in all these years? Why is this basic Constitution? Why is this basic structures? Why do they keep why are they so arbitrary? Anything and everything can be a basic structure, or nothing can be basic structure. And I can give you examples of this. For example, and I will come to you in a minute, Places of Worship Act, which I think was, in my opinion, that it went against the will of the people when Parliament decided that Places of Worship Act 1991, if you notice. Why has the Supreme Court not struck it down on basic structure principle? Because it impinges on my right to worship. So if there is a place of worship that is 100 years old and I want to claim ownership to it, I don't have the judicial remedy to do that, and Parliament took away that right from me. Why has the Supreme Court not restored my right to me in that sense? So my question is, why have the honorable judges in all these years not exactly defined, if our Constitution is codified, why have they not codified what is the basic structure so that there is absolute transparency?
So your question has two sides. One is academic, one is case specific. So I won't comment on the case because that is still sub judice.
Right.
I will answer the question academically. For that, we need to understand Keshwananda Bharati, nobody can understand unless somebody understands the first three judgments which were before Keshwananda Bharati. In the year 1951, there was a judgment. In the year 1964, there was a judgment. In the year 1967, there was a judgment. And then came the Keshwananda Bharti 1973. In the first two judgments of 1951 and 1964, it was held that Parliament has untrammeled power to amend even the fundamental rights. And everybody was happy with that situation. Then came 1967. In the year 1967, another extreme view was taken by the Supreme Court in Golaknath case. The Honorable Supreme Court held, and this was also, I think, 11 judges' judgment of the Supreme Court. 11 judges. They held that Parliament has no power to amend the fundamental rights at all. And therefore, that judgment was widely criticized, that how can the Parliament be divested of its power totally? Another occasion arose before the Supreme Court in Keshwanand Bharti case to test the correctness of that judgment, and a 13-judge bench was constituted because the earlier judgment was 11 judges. This is done very exceptionally. And that 13-judge bench returned finding with a narrow margin, majority 7, minority 6, a divided Supreme Court. But what was ultimately held, one perspective, it was in the favor of the government. It was in the favor of the Parliament. Other perspective, it was against the Parliament. So some people define it as if you have given a cow and a cat with the cow. So what was that cow? Cow was that the earlier judgment of Golaknath said that you don't have power to amend the fundamental rights. But this judgment held no. Parliament has the undoubted power to amend even the fundamental right. After having said so, the cat is the basic structure doctrine. That though you can amend, but you cannot alter some basic structure of the Indian Constitution. And it was wisely thought that it is a very difficult exercise to define what is basic structure. So different judges wrote different judgments concurring, and it was, in a broader sense, it was held that whatever is mentioned in the preamble, equality, liberty, dignity, etc., these are the basic structure. Separation of power, which is mentioned in the directive principles of state policy also, is the basic structure. Independence of judiciary is an aspect of separation of power, is a basic structure. Judicial review, that is the role of judiciary in constitutional democracy, which is today's topic, is basic structure. Because unless there is judiciary to interpret law, who will decide whether the executive is within its domain or the legislature is doing the work within its domain? Who is to decide? It can't be left to the decision of the legislature itself. It can't be left to the decision of the executive itself. There will be total lawlessness. Therefore, it is the job of the judiciary to interpret law. Therefore, judicial review was also held to be basic structure. So the theory of basic structure was laid down in Keshwanand Bharti case, is criticized by only those people actually who don't go very deep into the history of this judgment. This judgment, rather, Parliament should have welcomed. It has restored the power of Parliament to amend even the fundamental rights. With a rider on it. And nobody should be aggrieved of that rider. What is that rider? You will not take somebody's liberty. Should the Parliament otherwise take somebody's liberty? If the court So therefore, it's a matter of perspective. Ultimately, there is nothing wrong with the judgment. And I tell you very interesting thing. The same judgment which laid down the theory of this basic structure ultimately did not pass order against the government. There were 4 amendments which were under challenge in that case. 24th Amendment, 25th Amendment, 26th Amendment, and 29th Amendment.
Correct.
24th Amendment was formal in character. Even after holding so that Parliament has a power, but there is a implied restriction on the power of Parliament to amend, 24th Amendment was upheld. As far as 29th Amendment, 2 land laws of Kerala was put in the 9th schedule, and they were insulated from judicial review. In that judgment, it was upheld. Keshwanand Bharti case, that challenge was dismissed. even after holding so. That was also in favor of the government. Then 26th Amendment was the abolition of privy purses. That was de-tagged. And in the year 1993, in another case, Raghunath Rao case, that amendment was upheld, despite this basic structure theory.
Yeah.
Then there was 25th Amendment, which was subject matter of challenge. That was partially upheld and partially set aside. What was that part which was set aside? That part said that when the parliament makes a law purporting to exercise power to give effect to directive principles of state policy, the court will not investigate into the matter whether they are actually giving effect to the directive principles of state policy or not.
Yeah.
That portion was questioned.
Yeah.
That you can't take the power of the court to examine this question whether the law which you have made purporting to be giving effect to the directive principle of state policy is actually a law which actually gives effect to the directive principles or otherwise.
Yeah.
So what is that in it?
Yeah.
So the Keshwan Bharti case, which laid down this law, did not quash the amendments made by the parliament. Which is the question of judicial overreach. It is only an opinion which is narrative which is built. That court in that case had said so and that. If you go deep into that, that judgment has not done any wrong. Now, what the right that judgment has done in future, you will be surprised to know and pleased to know rather. That judgment was for the first time put into action in a matter which is Indira Gandhi election case. When Mrs. Gandhi election was quashed, an appeal was filed by Mrs. Gandhi in Supreme Court. During the pendency of the appeal, they also brought, because they were in majority, emergency was imposed and all that, they brought 39th Amendment saying that retrospectively, the power of the High Court to hear election petition is taken away. And this basic doctrine theory was used to quash that amendment. Is it wrong? Any student of law, any lay person would say that anybody would have quashed that amendment. Taking recourse to this basic doctrine theory, that power of judicial review is the essence of the Indian Constitution. You can't bar the courts looking into the correctness of elections or whatever dispute of the Prime Minister or whosoever high he or she may be. That was quashed. This was the first time this basic structure doctrine, which was formulated by the Honorable Supreme Court in the year 1973, was tested in the year 1975.
Yeah.
Then came 1980, another case, Minerva Mill case. What is the background of that case? When in Keshwan Bharti case, it was held that Parliament has the power to amend the fundamental rights and the Constitution with implied restriction of basic structure doctrine. Parliament did not digest it. Majority. What they did, they introduced 42nd Amendment, by virtue of which they introduced clauses 4 and 5 in Article 368 of the Indian Constitution, which deals with the power of the Parliament to amend the Constitution, and said that any amendment made by the Parliament shall be insulated from challenge before the court. That was to undo the effect of Keshwan Bharti case. Because Keshwan Bharti case said, we will do judicial review on a limited ground, whether it is violative of the basic structure. And Parliament said, under that amendment, this power to examine is taken away.
Yeah.
That was quashed in Minerva Mill case. That is the second occasion when this judgment of Keshwan Bharti was put into action.
Yeah.
Then in 1997, another case, L. Chandra Kumar case, this judgment was put into action. What was that? The role of judiciary in India was taken away in piecemeal fashion, and tribunals were created for adjudication of various matters like service matters, tax matters, this and that. By the argument that the courts are overflooded and we should have expert bodies.
Right.
Now, once the expert bodies are created, what was said that on all matters on which this body has jurisdiction, that is the tribunal, the High Court will not exercise its power of judicial review with respect to those matters which have been assigned to tribunals.
Yeah.
That was quashed in the year 1997. And then in the year 2007, another amendment was quashed that is also of such nature. So all the amendments which were quashed were such amendments which had to be quashed in any case.
Yeah. Fair enough. You talk about Indira Gandhi issue and you talk about the good points of the judiciary. Let me tell you that, a lot of times the worry is that this judicial review does become judicial overreach. For example, if in the case of, I think it was when Ramakrishna Mission had gone to seek minority status in, I think the case was before Supreme Court. At one point, the Supreme Court in its thing said, Hinduism is a way of life. That statement now has become a so-called guiding light of all conversations that we have in public sphere. When Supreme Court says Hinduism is a way of life, is it not going into the territory that it is not really trained to go into, or it does not need to go in? One. Number two, when Supreme Court says that we are going to go over BCSCI and how the cricket is run, for example. Now, Supreme Court wants to monitor BCCI, which is a private organization, and wants to, they have a committee or something for running of cricket. Now, is it Supreme Court's job to run cricket? Is it Supreme Court's job? I think Arun Shourie had written a whole book about how Supreme Court had at one point said how many times the mosquito repellent should be used in a city. Is this the job of the Supreme Court? Because such things have also come to Supreme Court, and Supreme Court has talked about these things. So where do you draw a line between judicial review and judicial overreach? Because a lot of times we see that Supreme Court is talking about things that it has no expertise to talk about.
Very interesting question and very debated question. This judicial review has two aspects. It is the judicial review of the executive failure or executive action. It is also judicial review of the legislative action. You are talking about the cases like BCCI you have mentioned. BCCI, according to Supreme Court, has held that BCCI is performing public function because it is controlling a lot of funds. It is controlling the game of cricket in India. A lot of money is there. And a lot of politicians have vested interest in BCCI. So that prompted the Honorable Supreme Court in a petition. It is not a suo motu. Some petition came before the Honorable Supreme Court. And Supreme Court intervened into the matter. And if you go deep into that, what the Honorable Supreme Court did thereafter, with the intervention of the Supreme Court, many things have been put on rail. Otherwise, BCI was going the other way around. So there are many other things. Many unpopular decisions are taken only by the courts, not by the executive. Like in Delhi, a lot of pollution in the 90s. Who introduced CNG?
Yeah.
Had the Supreme Court not been there, nobody would have introduced the clean fuel in Delhi. Who banned the over 10 years old diesel vehicles in Delhi? It is only Supreme Court.
But so that is the basic question, Mr. Bhushan. Is that Supreme Court's job then? Is policy making Supreme Court's job? Because that is not the job. I understand that executive might be flawed. I understand that executive might fail. I understand legislature might fail. But then they go to the court of the people every 5 years, and then they are subjecting themselves to that kind of scrutiny. So even if it is done for the right purposes, you say that, see, the pollution got Supreme Court introduced CNG buses, but now that is policy making, that is going into the policy making. Is that Supreme Court's job? That is not Supreme Court's job. It is the job of the executive. So even if things are going wrong and it may be done for the public good, But in the larger perspective, that is Supreme Court going beyond its remittance, going beyond what it is supposed to do. That is the real crux of this whole heartache.
Very nice question. In the Under the doctrine of separation of powers, legislature has been given a role, executive has given a role, and whatever role is not assigned to them is the role vested in the Supreme Court or the judiciary.
Right.
So when there is a failure on the part of authority to perform its role, the Supreme Court comes into picture, and in most of the judgments which we are talking about, what the Supreme Court says, we hereby lay down the guideline till the suitable legislation is made. In such policy matters, Supreme Court never gives the final verdict and final word. In all judgments where the Supreme Court intervenes in policy matters, it is with the aid of first of all, the experts. Panels are constituted. They are included in the bodies. There are so many cases right now in the Supreme Court. And ultimate judgments and orders which are passed are well guarded. They are alive to the situation that is not their primary duty. But they can't shut their eyes. If the other two authorities are not working, then who is to perform that? Who is to fill that? And Supreme Court has used that expression. We are filling the vacuum only.
Yeah.
And most of the judgment you will find, till suitable legislation is made, we direct as under.
Yeah.
And then there are many cases where suitable legislation is brought, and the Supreme Court directives have been undone. Undone. Without any protest from the Supreme
Your
Court.
position is that till the time, if there is any executive failure or if there is any executive thing, we cannot let the country suffer. Supreme Court steps in that time till the suitable legislation can be made. That is your point. Okay, fair enough. Let me now ask you a question that under the separation of powers, if Supreme Court is the moral guardian and the constitutional guardian, why does Supreme Court not turn the mirror on itself? And when it comes to the appointment of the higher judiciary, why does it not believe in separation of powers? Why is the appointment of judges so opaque that no one ever knows how people are recommended to the judgeship? And we have seen cases of nepotism everywhere. I mean, it is not anybody's case. You just have to look at it. 3 generations, 4 generations, 5 generations of oil become. There's nobody should stop anyone from pursuing their parents' profession. That is not my position. My position is that these people then become the judges. These people then become things, and it does. You have seen cases where 3 generations of a family, all of them have ended up becoming judges, and it is because there is this silent going on there, because there is no sunlight. Supreme Court does not want any sunlight on itself. So while Supreme Court has put itself in the moral authority that when there is a vacuum, I will step in. My question is, when there is a vacuum in Supreme Court's decision, who is going to step in? They're not allowing executive to step in there at all. Look how they struck down NJC.
Very pertinent question. So I'll start the answer by saying that no system is perfect. It is only the perfect people which make even the imperfect system perfect.
True.
And imperfect people make the perfect system imperfect. So it is all people-centered. It depends who is in the chair. But broadly, we have to answer this question. So out of 2 given options, one appointment by the executive of the judiciary, and one is appointment by the judiciary of the judiciary, I feel the appointment by the judiciary of the judiciary is a better option for so many reasons. Right now, it is appointment by the judiciary of the judiciary, but are they in a position to actually appoint? Who is stalling the appointments? Why there is a lot of vacancy position? Because ultimately the appointment order has to be issued by the executive. And despite so many judgments, they are not doing that. So there is total deadlock between the executive and the judiciary. So in order to answer the question which you have raised, we need to understand what attempts have been made post 1993 by the executive to regain the lost territory,
Mm.
because they think as if it was a battle of Panipat and they have lost their bastion and they want to recover it from the judiciary. So many attempts were made. The first attempt which was made was in the year 1990. Few people know that a constitutional amendment bill, I think it was 67th constitutional amendment bill, which was introduced in the year 1990 to create a NJC, National Judicial Commission. That could not be passed because of the dissolution of the houses. In that, a very interesting provision was incorporated. This is prior to the current NGSC. I will just come systematically. In that, it was said that the chief minister of the state would also be member of the panel for appointment of the High Court judge.
Mm.
But fortunately, that bill could not be passed and the houses got dissolved, and thereafter that move was debunked. Then in the year thereafter came 1993, 1998 Supreme Court judges judgment and all that. Then in the year 2003, another attempt was made to create a National Judicial Commission. And this time the National Judicial Commission was the Chief Justice of India,
Yeah.
the two senior most judges, and the Law Minister of India, and one eminent person appointed by, in the proposed bill, it was Prime Minister of India. So five member body, where the majority was of the judiciary, one was a union law minister, and one was an eminent person to be nominated by the Prime Minister. That was also not passed because it was not debated, and the Lok Sabha, Rajya Sabha, whatever it is, got dissolved. Then came in the year 2013, another bill was introduced by the UPA government before the NDA came into picture in the 2014. That an attempt was made to create a National Judicial Appointments Commission, but it was said that we are only making a provision in the Constitution. Parliament will later on make a law and define what will be the shape of the commission. That was a half-hearted attempt. Then came the government of 2014 and came the new bill, which was ultimately converted into an act of parliament and quashed in the year 2015. That bill actually was continuation of 2013 bill. 2013 bill or 2014, which actually became the act, had a very sinister provision, and that was rightly quashed.
Mm.
That was a very intelligent move on the part of the executive to actually take over the role of the judiciary in appointments. What was that? Chief Justice of India, two senior most judges, law minister, and two eminent people to be appointed by a committee consisting of the Prime Minister, Leader of Opposition, and Chief Justice of India. So it was a six-member body.
Mm.
Six-member body where judiciary has no primacy now, because 3:3 can be there, so no decision could be taken. And there was another interesting provision. A bill was also introduced, ordinary legislation, National Judicial Commission Appointment Commission Act 2014. One is constitutional amendment, one is an act, and that act had a provision that any two members of the six-member body have veto power. If four agree and two don't agree, that recommendation will not be made.
Mm.
So what was that? That has to be struck down because that was actually running at the face of the doctrine of separation of powers.
Mm.
This was a way to take over the judicial appointment. Then it would be appointment like any other appointment by the government of the executive. Appointing a minister is the prerogative of the Prime Minister, and appointing a judge would also become like that. And
Yeah.
what can you expect from that judge who is appointed by the executive this way?
Let me
Therefore,
ask you this. Let me ask you this. Since you're also a student of comparative law, look at how the Supreme Court judges are appointed in the United States. And I have a lot of viewers who are actually asking me that question right now. The judges in the United States, they go through, I'm sure you must have seen the hearings and what they go through when they are being appointed, or when the process of appointment is going on. They have to go through scrutiny of a level that is unheard of. In fact, in Judge Kavanaugh's case, they actually brought out his this is going to the other extreme. They actually brought out what he had written in the yearbook of when he was in high school. I mean, 12th grade or something. Something he had written as a 17-year-old. They brought out and they put it against him. So that is the level. That's another level. I'm not saying that that was right. But that is another level of scrutiny, that your work now from the time you were in high school is under the scrutiny of the Congress, US Congress now, both of us. That kind of scrutiny, judges of Indian Supreme Court don't go through. So whatever the scrutiny that goes through, the judiciary tells us they do go through the scrutiny. It is in the minds of the judges. We don't see it. In United States, this entire deposition is being held in camera. Most people can see what is going on between the Congress and the judge who has been, appointed, or whose name has been suggested by the executive. That kind of scrutiny doesn't happen in India. And Indian judicial system, while they look up to the American system or the British system, they don't subject themselves to that scrutiny. And that's where the problem arises. Whatever the scrutiny happens, your point is, the judiciary's point is, trust us. Well, we don't trust the executive. We don't trust the legislature. In a good, healthy democracy, there should be no question of the trust. The question should be transparency. You cannot say, trust me, I am doing good for you. That principle does not hold in my sense, because then that goes against democracy, that goes against basic structures, that makes it an authoritarian principle. Trust me, I know what is good for you. I know who's the better judge for you. So what do you have to say about that?
This is an impression only. I will demonstrate how it is an impression, not the reality. The reality is that after the judge's judgment, there is a MOP, Memorandum of Procedure for Appointment of High Court and Supreme Court Judges, which has been formulated by the Union Government in consultation with the then Chief Justice of India. And that is not a static document, keeps on changing, and some amendments are made here and there thereafter. What is that document? You know how the judge of the High Court is appointed. The Chief Justice of the High Court, in consultation with the two senior most judges of that High Court, recommends a candidate. 4 copies are sent, one to the Chief Minister, one to the Governor, one to the Union Law Minister, and one to the Supreme Court for information.
Yeah.
When it goes to the Chief Minister and Governor, they do the local inquiry. When it goes to the Union Law Ministry, they give it to the Intelligence Bureau. And Intelligence Bureau comes with all sort of reports, public perception and all that. Their reports sometimes are only based on impression. Then after that scrutiny at the level of the government, that proposal with all objections and material is given to the Supreme Court. And if that contains some material against the candidate, the Supreme Court may ask for clarification.
Supreme Court has the right to overturn and overlook that, right?
No, right now, let me answer the question. Suppose the Intelligence Bureau report is, which is also part of the record, that according to public perception, this man has link with lot of antisocial element. Suppose he is a very renowned lawyer, lot of clients he has. He would not be doing any temple business. He will be handling cases, and many criminals would be meeting him. He may be a good professional, but he has to interact with those people. And sometimes the reporter that he has been a lawyer of such and such. Is the Supreme Court not within its jurisdiction to ask, give us some concrete material that is part of the crime, or he is only doing his professional duty? So that is not interference with the scrutiny. That is only putting the things in perspective. I know a case, I cannot name because a friend, who went to a foreign country when he was a lawyer, and he went to a foreign country which is known for as a people go for other purposes, and then then that person appointment was delayed for 3 4 years just on the ground that he had been visiting that country. So there was no material. Ultimately, he was made a judge. So there are many things. Sometimes on very fishy reports, the proposals are withheld where the government is not interested in carrying out. And the Supreme Court then doesn't put its foot down, simply says what is the material that is provided in the MOP. Now, what is the procedure? After that clarification, the Supreme Court applies its mind and agrees with the executive. Proposal is finished. Supreme Court applies its mind and ultimately says no. We reiterate our proposal. And after the proposal is reiterated, the judgment says and the MOP says that the president has to issue the appointment order. So that is the limited area of conflict. We have
Mr.
seen.
Bhushan, I agree with you that there is. Okay, go ahead. I want to bring a counterpoint to that once you finish. Yeah. Once you finish, please go ahead.
We have many cases where appointments are made in 10 days, and we have many cases where appointments are not made for 2 years.
Yeah.
So ultimately, the key lies with the executive. I will come to the point when the interview proceeds further that what can be the possible solution. I will right now. Let me not talk about that.
Let me give you a counterpoint to when, and we'll talk about the solutions later. The counterpoint to your thing is that Supreme Court applies its mind and it takes into account the scrutiny or the reports that have come from various resources. Proof of the matter lies in pudding. Why do we see lack of diversity in the appointment of judges then? Why do we see lack of meritocracy in appointment of judges then? And then why do we see so much nepotism? Why is, film industry right now gets banned for nepotism? But I've always said that Bollywood is kindergarten of nepotism. The major big daddy of nepotism is the judiciary. And I'm saying it, you're not saying it, so all the contempt just goes to me. But I'm saying that judiciary is the big daddy of nepotism. So I'm saying that if Supreme Court did apply its mind, we would not see lack of diversity, we would not see lack of meritocracy, and we would not see so much nepotism, because proof is in the pudding. We see it. So grandfathers, fathers, sons, and grandsons, they're all becoming judges of Supreme Court.
So grandfather is a judge of the Supreme Court, son is judge of Supreme Court, and the grandson also becomes the judge of the Supreme Court. This is not only true about judiciary, it is happening in executive also. We have political families where third, fourth generation are chief ministers.
They go to people for elections. That is the main difference. They have to go to the people. They have to fight an election. And trust me, fighting an election is not easy. Even if you are...
you would agree with me. Me and you cannot fight elections. For fighting elections, you require a lot of resources.
I am not saying that judges should fight elections. That's not my point.
I'm saying nepotism in each and every field.
Yeah.
So that is something which varies from case to case. It is not that there is no merit in the Indian judiciary because and there is no diversity. This is also not the correct. We don't have data right now. But I tell you very honestly, we have a lot of diversity and no adequate representation. There are notes that a representation is given to the scheduled caste, scheduled tribe, women and all that, subject to certain minimum merit. Not that simply that somebody belongs to a class, scheduled caste, backward class is to be judged, but it is always kept in mind and it is official, not unofficial. It is always kept in mind in a particular high court that how many judges have been elevated from this class, that class, caste and creed. Everything is taken into account. So let's not go into that. But the flaw in the collegium system, I say which one is the better system out of the two. Then I say collegium system. But I don't say it is the perfect system. I say there is a flaw in the system that, according to public perception, this system lacks transparency.
Yeah.
There is no permanent secretariat. There is no system that people can put their applications for consideration. It is only pick and choose by the three senior judges of the court. So that is why many people feel that for every public appointment there is a process of appointment, but here is a system where somebody is picked up, and there is no application, there is no permanent secretariat, there is no interview, there is nothing. And we have seen many times that people who failed in writing the lower judiciary examination after 10 or 15 years become the high court judges. And their colleagues are still in the district judiciary at the rank of additional district judge or something like that, and they go to the high court, and they also become Supreme Court judges. There are numerous instances.
I'm glad you said that. I'm glad you admit that. Yeah.
Therefore, what I propose, I see a solution akin to 2003 model, which was introduced by the then UPA government. That National Judicial Appointment Commission was not consisting of 6 members. That was 5-member commission, where the primacy was Chief Justice and 2 senior most judges, Union Law Minister, and 1 person appointed by the Prime Minister. That can be taken care of. That 1 person can be appointed not by the Prime Minister but by a panel, like in 2014. So there can be a hybrid type of commission where the 3 members are from the judiciary, 1 is the executive, and 1 is an eminent person. That eminent person guidelines can be there. He will be eminent professor of law, or an academician, or an accomplished person in his own field who can be trusted, whose wisdom can be trusted, or a eminent social worker. And his appointment by a panel of 3 people: Prime Minister, Leader of Opposition, and the Chief Justice. And decisions have to be taken by majority.
Yeah.
The judiciary will have no problem, should have no problem, because they are 3 in number, and the other people will be only 2 in number.
Yeah.
But the benefit of this system would be that the allegation of the executive that they are totally excluded in the appointment will be taken care of, with the result that in a very cordial manner, the appointments can be carried forward. Ultimately, judges should not have any agenda to appoint their own people. They should have the agenda to appoint the correct people.
The best people.
And in the judgments, they write that our purpose of taking the control is to bring the best of the merit. So once there is an award, their aim is like that, declared aim is like that, nobody should have a problem with such a commission. And right now also, ultimately, what we are gaining with the collegium system, appointments are still withheld. Ultimately, the final say is with the government, and then the government is also complaining that they are not in the process. The final say is with them, but they are still complaining they are not in process.
The final say is only, it is only because they don't get the right to choose the person.
It is very important. It is very important because right now there is a contempt petition going on the Supreme Court. What happened? After all these judgments, the Supreme Court thought in the year 2021, some lawyers in Orissa High Court went to strike. Some case came before the Supreme Court, and Supreme Court saw that there is a lot of vacancy in that High Court and lawyers are on strike and all that. It took suo moto cognizance of the situation and said that whenever a recommendation is reiterated unanimously by the Supreme Court, it should be, the appointment order should be issued within a period of 3-4 months, 3-4 weeks, 3 to 4 weeks. That direction was passed in April 2021, not being complied with. Right now, the Bangalore Advocates Association has filed a contempt petition to the Supreme Court. Supreme Court is simply saying time and again, but Supreme Court is not in a position. Ultimately, the executive has to issue the order. The Supreme Court will not issue the appointment order. The Supreme Court will not administer the oath. Therefore, ultimately, the final say is otherwise in their hands. Why don't we include them with the majority of the judges in the panel? 3 judges, senior most, like in the present collegium. And one executive and 1 eminent person whose appointment is by a 3-member panel, including Chief Justice of India. At least they would not be having any excuse that we are excluded from the process of appointment of judges. This is the best way.
Some amount of transparency, and the public perception improves, and people don't feel that judges are appointing themselves.
And I tell you,
is very important.
I tell you one thing, that if this system is adopted, There can be a permanent secretariat of the commission.
Yeah.
Applications can be invited. What happens now? The people who have roaring practice, they don't want to become the judges.
Yeah.
The people who are very meritorious, they don't have face in the court. Nobody knows them.
Mm.
They may prove to be the best judges,
Yeah.
but they don't have access to the collegium. So ultimately, who becomes the judge then? In between. People who are accomplished, they decline.
Mm.
And people who are actually very good in academics and they can be very good judges, they are not noticed.
Yeah.
If that system is adopted, at least that section of people who are deserving but who don't have appearance for the court much, or who are not noticed by the collegium, they can put their applications and they can be interviewed and all that.
Yeah.
We can have the best of the judiciary.
Fair enough. Fair enough. Best of both worlds. I'm almost at the end of it, but I'm getting a lot of questions. We'll try to quickly take 3 or 4 questions, Mr. Bhushan, because there's a lot of interest. People are actually watching carefully. One question is, and it is a question said in lighter vein, but it is a serious question, I would say. The person wants to know that why do Indian judges have such thin skin? Why do they put a slap contempt of court on everybody and anybody? Why can we not criticize judiciary? If we can criticize everybody, if we can criticize the prime minister of the country, if we can criticize the chief minister of the country, if we can criticize everybody, why can we not criticize the judgment of the Supreme Court? Agreed that there should be no personal attacks or anything. Nobody is saying that there should be ad hominem, but why can the text of the judgment, why can the judgment not be why can people not criticize it?
The answer lies in the question. There are 2 types of contempt under the Contempt of Court Act. One is the civil contempt, that is the violation of the court order, direction, undertaking. The other is scandalizing the judge, the institution, not the judgment.
Yeah.
If you criticize the judgment, that is not the contempt under the Contempt of Court Act.
But judges take offense. You have to admit, judges take offense very easily in India.
So that is case-to-case basis, and there are lawyers to defend those clients before the court, and ultimately the contempts are dropped also.
Yeah.
So that I can't comment.
I know my colleagues who have been hauled to courts for contempt for things they have said.
Maybe instances, because some judges who may not be well trained in the application of the contempt jurisdiction think that contempt is a tool which, according to the Contempt of Court Act, the contempt is of the court, not of the judge, and even a judge can commit the contempt of the court because contempt is of the chair.
Yeah.
I have a personal experience in a case where a judge threw a file when I was a trial court lawyer. A judge he became very passionate and he threw a file. And I said that according to such and such section of the Contempt of Court Act, even I can issue contempt notice to my lord because you have thrown the file at my face. You are committing contempt of the court. Contempt is of the court, not of the... By the judge also it can be there.
Okay.
So this is a very general question, case-to-case basis.
Okay. Another question is, Mr. Bhushan, you have batted very well on behalf of judiciary today. Is there anything that you would like to change in the judiciary if you were given an option?
So change is the rule of life. Change is always welcome.
Yeah.
First of all, we have to change only the appointment system.
Right.
So after having batted for the judiciary, I'm not saying that everything is perfect. And even the NJC judgment, one of the judges who quashed the NJC, he expressed his opinion about the weaknesses of the collegium system.
Yeah.
Despite the fact that the amendment was quashed.
Yeah.
So, and judges talk privately, retired judges and all that, and there are many people who feel that the system requires change. And therefore, the change which I have suggested is also the change many jurists in India they have started talking about. That is the only way to overcome the deadlock, and that will actually help the judiciary and the executive both.
Yeah. Fair.
Executive requires judiciary.
Yeah.
It's not that only judiciary independence is not required only for judiciary.
Yeah.
The independence of judiciary is required even for the executive,
Yeah.
because all unpopular decisions have to be taken by the judiciary, which executive cannot face. So,
True.
for the survival of the system, the survival of the judiciary is a must.
Yeah. I have a counter question to that, and then we'll probably end this. What do you sometimes I feel, and this is my personal question, sometimes I feel that executive, when they don't want to take a decision or they don't want because they have to face people, they very conveniently lay the ball in the court of the justice, and they say ki ab aap karo, whatever you need to do, you do whatever, because they don't want to take the decision themselves. They don't want to be the bad guys themselves. In those cases, is there a collusion?
No, there's no collusion. It's a way of working,
Mm,
the bureaucratic way of working.
mm,
That matter is pending in the court, let the court decide.
mm.
Even if you have the power to decide and put the matter before the court that now it has been decided, maybe court disposes of the case
Yeah,
according to your decision. But
yeah,
nobody wants to take the decision. They want to pass on everything to the court. That
yeah.
is why the government is the single largest litigant before the courts.
True, true. Another question, and I have to ask this quickly, is what do you have to suggest for the growing backlog of the cases? You know, there are so many cases, an average person, and there are two parts to this question. A, average citizen does not have the same access to the judges. I mean, to the lawyers that somebody who is in a privileged position does. In a democracy, that is a travesty. As far as judiciary is confirmed, as far as lawyers, access to lawyers is concerned, it must be given to everyone, because this is the only way. This is not a privilege. Judiciary, I mean, access to law and access to is a right, is a fundamental right of every person. What can we do to improve the access and improve the affordability also? Because a lot of lawyers, ordinary people cannot even afford.
So the question has many angles. First of all, we need to understand that there is no one single reason for the huge backlog.
Yeah.
There are so many reasons, and it's a rippling effect of one reason over the other.
Mm,
According to me, the basic reason is the what is the ratio of the high court judges in India?
mm,
We have for 1 million there should be one judge ideally of the
true,
high court.
true.
So our population is 140 crore,
Mm,
1400 million. We require at least 1400 high court judges.
yeah.
Right now we have 781
Mm,
high court judges in India. So there is a vacancy deficit of 42% nearly. And this is how our system is working.
mm,
So with 42% vacancy, this institution is working.
mm,
It has the rippling effect. Then, because of the judiciary and the executive at loggerheads over appointments, many constructive things are not being done.
mm,
Ultimately, purse is controlled by the executive. Who will release the funds for infrastructure?
mm.
Judiciary will not. Judiciary is not a revenue earning institution. It depends upon and there is no commission in India, Judicial Infrastructure Commission. They don't have independent funds. For every requirement, they have to go to the executive.
Mm.
And because of this conflict between the judiciary and the executive, nothing is happening.
Yeah.
So there is infrastructure issue, there is vacancy issue, appointment issue, and training of the judges issue at the lower level. And then alternative dispute resolution mechanism is to be strengthened so as to litigation. Rather than dealing with the litigation, it's better to avoid litigation. Like
Agreed.
preventive health is better than the curative health
Mm,
treatment.
yeah.
The same. So many things are required to be done, but that is possible only when there is peace.
Yeah.
There should not be collusion, you are right, but there should not be a fight also.
Mm.
Collusion is bad.
But constantly fighting is also not good. There has
and
to
at,
be some middle ground.
and at public forum.
Yeah, yeah, I
At
agree.
public forum.
Yeah,
That is very disturbing.
yeah,
That should be avoided.
yeah. I have to end this now, but I cannot let you go without asking this question. Do you think there should be a cooling period for the judges after they retire to accept any position with the government? My personal opinion is that there should be a law that they can never accept a position with the executive with the government. That is my personal view. But what is your view? Should there be a cooling period at least?
Emphatically, yes. And not cooling period, there should be a total bar.
I agree with you. I agree with you.
And the judges can be compensated with better pension,
Yes.
or even the retirement age can be increased because of the life health
Life
improving and
expectancy.
like
Yes.
that,
Yes.
longevity and all that.
Yeah. Yeah.
So
Yeah.
65, it can be made 70 years or something like that.
Yeah. Yeah.
But no appointment thereafter.
Yeah. I am glad we agreed on this, and this is one thing that I will end on this. It's always good to end on a note of agreement.
Agreement.
Yeah, so we agreed on this that there because I am totally against this. I don't think judges should be offered a position, and everybody is guilty of it. I'm not saying anybody. Everybody is guilty of it. The judiciary is guilty of it for accepting it. The judges are guilty of accepting the positions. Executive on all sides of the political spectrum are guilty of it. Everybody, nobody comes out looking good in on that field at least. So
And this is very much required for independence of judiciary.
I agree. I agree. If there is one thing that will really make it important for the independence of judiciary, this is the most important thing, and this is what we should fight for, and this is what we should hope that it gets implemented. Thank you, Mr. Bhushan, for your time today. I have a lot of questions that I haven't had time to ask. People are already asking me for a part 2 because they feel that they would like to go over a few judgments in detail. My team will get in touch with you. We will probably have a part 2 pretty soon. But thank you for your time today. You've been very candid. You have forcefully put forth your ideas. Now it is up to the people, how they make up their mind on this. Thank you so much for being on Epicentre today.
My pleasure. Thank you.
Thank you. Thank you to my audience for being here. This was one of the topics that all of you had asked me, that we should be discussing the role of judiciary in constitutional democracy. It is a huge topic, and it's impossible to talk about it in 1 hour, but we did our best. And we will bring a part 2 of this conversation as well. If you like what we are doing here, if you like these in-depth conversations, if you like these elephant in the room conversations, then please do subscribe to Epilogue News Network. Follow our handles, our social media handles. Subscribe to us on YouTube, share our videos, and keep in touch with us and tell us what you would like. So follow us, subscribe us, share our videos, and I will be back with you with another guest in an equally scintillating conversation. This is Sunanda Vashisht signing off.